Okay, good evening, everyone, and welcome to the first in a new series of seminars with Mohammed Haque, who is consultant barrister, adjudicator, and quantum expert for Silver Shemmings Ash. Tonight, Mo is going to be talking about making a claim and the starting points for that, and sharing his considerable expertise with you. As always, if you have any questions or anything you'd like to ask Mo at all, please don't hesitate to use either the Q&A or the chat tools in the toolbar at the bottom of your screen. And at the end of the session, he will happily answer these questions for you. As always, if there's anything specific you wish to address to Mohammed, then please feel free to email him. We'll show his email address at the end. Slightly different this evening, due to a couple of technical issues, I'll be doing the slides. So bear with us if I miss his cue. So without any further ado, I will hand over to Mohammed. The floor is yours.
Hi, hello everybody, good evening. And this is Mohammed Haque. As you might have noted that Julie was introducing me and then start saying Mo. So yes, I'm popularly known as Mo Haque. So I'm fine if I'm Mo. And for the next 1 hour or so, I'll try to share with you, as Julie said, my experience about adjudication, which is roughly about 10 years. And I've been acting as adjudicators for the last 4 years now. Also, obviously, at the same time, representing parties. Now, I started as a barrister, sometimes, as they say, the wrong way around. And for first 10 years of my practice, I have acted as a counsel, mostly in international arbitrations, and in Asia, though where the proper law of contract was English law, and most of those somehow was construction arbitrations, and in various sorts of bigger projects, infrastructural, mining, oil and gas, coal mining, whatnot. And after about 10 years, we were having difficulties to be overseas family-wise, so we've come back to London. And what I found was that because of my experience in construction, probably adjudication would be a better route. Around the same time, I thought that I should understand construction a little bit better. So what I have ended up with, I've done a BSc in construction from the University of Reading College of State Management. And Julie, I think there is a problem with the screen.
Yeah, I'm just trying to sort that. So if you carry on, Mo, I'll get that dealt with.
So that's about it for the last 10 years. As I said, I practiced as a construction adjudicator, as well as a construction adjudication party representative. Now, what I felt really is that in the market, there are various courses, trainings, discussions held. You can go to the next slide, Julie.
Okay.
But no one really holds a series of how you represent a party if you decide, or if you are a party yourself and decided, because it's ADR, I can do it myself. How do you actually do this? So the usual stuff is you go to a course or a training or a talk, and people brings in loads of case laws, natural justice, this, that, the other. What is a dispute? How it crystallizes? And see, the bottom line is, like Lord Colson has recently said extrajudicially, that how often you have seen in your life that in an adjudication proceedings or in an enforcement, a dispute has been decided as not been crystallized. And he answered himself. He said, almost never. So what's the point of learning all these case laws where I'm not saying you don't have to learn it, but there should be something on the market or the industry where you really learn how to draft an adjudication claim, when to draft it, or to make a strategic decision that, yes, adjudication is the right kind of forum for me to go ahead. So I was thinking about it for a while, and I have come back, or almost in the process of developing a course for the CIR to be attended. It's going to be a non-pathway. So this is an attempt actually to replicate that, and I'll be running the series for the whole year. So today I'll be doing the introductory one, and then I'll go how to respond, how to do this, how to do that. Julie, if you could go back to the earlier slide for a second, please.
Yeah, no problem. Sorry, I'm just having a few technical issues here. Zoom has crashed,
Right.
And now I'm having to liven it up again. So bear with me, everyone, and apologies for any ruining of your enjoyment. That one or the next one?
Right. Yeah, no, this one should do. Now, I will start with just briefly telling the scope. I'm going to concentrate on construction adjudication because there could be other adjudications in practice. And so we should first know what is a construction adjudication. But what I'm trying to include in this by construction adjudication, I'm referring to the compulsory process, which is part of every single English construction contract, unless excluded by the statute, meaning that the parties cannot exclude that. That process I'm referring to. So if you are familiar with construction industry, you know that in late 90s, the statute created a special thing called adjudication. It is sometimes called statutory adjudication, sometimes or popularly known as construction adjudication. What the piece of legislation in 1996, Housing Grant Regeneration Construction Act, I'll call it an act or call it the act, did also was, and that's what is one of the two things I will touch upon, is introducing a payment regime, meaning that if you are a party to the construction contract, if you are a payer, you have to pay regularly, and there is a process involved. If you're a payee, you have a right to claim the money regularly, and if you're not paid, you can adjudicate. So this particular statute has rules made under it in 1998, and as usual, there are amendments to it as well. And so by the word statute in this slide, I mean the act and the rule, which is popularly known as the scheme. Obviously, we have also legal rules we have to be careful about when we are thinking to go to adjudication. That's case laws. The huge body of case laws under the statute gathered over the last 20 odd years. And obviously, if you're making a claim under the contract, because we are talking about the construction contract claim, so we have to be very clear about common law as well. That is the contract part of it. And in the fringe, other things will come in, and I will explain those as I go forward. The next slide, please. Hi, Julie.
Yeah.
All right. Okay. I got the next slide. Thank you. So that on a fine morning, if you're a contractor, if you're a subcontractor or an employer, you might think, well, this other chap, say if you're an employer, the contractor, what he's doing is impossible. I'm not gonna carry on like this. I got to make a claim. And you you consult the rule book, meaning the contract, and you see that that provides any difference or a dispute can be adjudicated. You get excited, but don't get so excited. You have to fulfill a number of requirements before you actually make the decision that you really can adjudicate. So the first thing is, do you have a right to adjudicate? And in answering that question, the first thing to consider is, are you a party to a construction contract? Take a note of these words one by one. Are you a party to a construction contract? Unless you are a party to a construction contract, you cannot adjudicate, right? The second thing is there a dispute which has arisen under the contract? So it's not that it's relating to the contract, it has to be under the contract. And only if you are a party to the construction contract, and there is a dispute which has arisen under the construction contract or terms of the construction contract, you have a right to adjudicate. However, we'll see into the next slide that there are some other considerations as well, which will go on later on to exclude, but these are the two fundamental things. And the next thing you got to think about is, how many disputes do you have? So your contractor, for example, you're an employer, didn't turn up yesterday, or your project was supposed to be completed by December, it's January the 22nd, or that's another one. And then the contractor is asking for payment and sending you certain things, calling applications, but you think he's so slow, I'm not going to pay him right now. That's another dispute. So how many, when we get a call from the clients, especially if they're lay clients, they start complaining about the responding party they have in their mind. And quite often we see 5 different things they're complaining about. But unfortunately, in one adjudication, you can only adjudicate one dispute, although there could be various legs of one dispute, but ultimately you should be able to wrap it up like one dispute. The next one is, I've already touched upon it, has a dispute crystallized? That means, is that really a dispute? Meaning, have you actually said to the other party that, wait a minute, I'm not satisfied with you for this, and I think I have a right to make a claim against you. And then he denied, he turned around, or she turned around and said, hang on a minute, I've done my job right, so you do not have any right to complain against me, or you do not have any right to make a claim against me. Until and unless that happens, the dispute in the technical language has not been crystallized. Well, if you hear the dispute, if you tell them that there is a problem you're having, and then they do not respond, they do not care, silence may result into a dispute being crystallized. But you have to take that into consideration. Finally, and not a very easy thing to decide, that is adjudication the right choice? There are different things in consideration. I will explain some of them later on, but one preliminary point I want to make a note of, that all of you, I think you all know, but again, the point is that the adjudication process doesn't allow a party to recover their own costs. Now, if you cannot recover your own cost, and if your claim is a small one, then you may see that by the time you earn 50K from a decision of an adjudicator, you have ended up spending almost 30K. So just bear that in your mind, and other things will come forward, other consideration, whether it's the right choice or not. So next one. Now, if you come to a conclusion that yes, you have an actionable claim. Yes, adjudication is your right thing to do. And yes, you'll go ahead, you have enough money, and the value of the dispute is quite high, and you have considered the cost implications, and you have found that you may have a right to the cost in a litigation, but it will be very high. And if you lose, then you may not get anything. So it's better to try this rough, cheap method of resolution. So you have made up your mind. Now you start working on it. So you start your preparation. First of all, identify the contracts. I cannot see any reason why you can't, but in practice, I have experienced that most of the time when I told my clients that I need to know the contract, the answer comes, well, we don't have a contract. And then, as I said already, unless there is a construction contract, you're a party to it, there's no construction adjudication. Why are the parties saying that I don't have a contract? It's because the parties popularly believe, even the professionals who are contract professionals, sometimes they believe that in order to be a contract, there has to be signed and executed a document containing all the rules and regulations and saying here and there, hereinafter, thereafter type things. It's not the case. As long as you have a relationship which one of the parties has asked the other party to perform a construction operation, for example, or just for the sake of making it very simple, asking someone to do some extension of a house, some foundation work, earthwork, doing your fence at the backyard and whatnot, anything which involves a construction, and you are not doing it on a friendly basis, meaning that the parties have understood that there will be a payment involved, there is a construction contract. It doesn't matter that it was entered into wholly orally, and it was even paid in cash. So, but what you need to do though, that you have to find out what is the contract between you and the other side. Then as soon as you complete finding out the contract, then you got to find out the parties. Because it very well could be that the contractor has been in touch right from the day one, and the correspondence were done by a partner, a wife of a particular person, and who always felt that he's been the party to the contract, but in reality, it could be that the wife will be treated as a party to the contract. I'll give you a more difficult kind of example from my practical background life, that it so happens that many contractors, they change their legal status from a sole trader or a partner during a project. They become a limited company, and they may have a contract with an employer entered into when he was a sole trader, but then he got himself registered, and there is a legal process involved to amend the contractual relationship called novation, but many a times it doesn't happen. And what worst is that the employer starts paying to the new limited company account, which remains maybe the same account number, the same VAT number and all, just being changed from an individual to a company. And then you have a dispute, and your client gives you, if you say, what are the parties? They say, okay, this is X Company Limited. And your party, you get the copy of the incorporation certificate, and you don't check the contract. You go to the adjudication to find out that, hang on a minute, I don't have a contract with this limited company. I had my contract with a sole trader, Lawrence, I knew. So who are you? And you'll be thrown off. So it's sometimes very easy, but sometimes if you're not lucky, it could be a difficult thing. So you need to find out the parties to the contracts, because only the parties to the contracts are allowed to make an adjudication claim. Now, the third thing is, I've been repeatedly telling you that it has to be a construction contract. So you have to identify whether your contract is a construction contract or not. Who can tell you? Very simple. Housing Grant Regeneration Act, or the Act, defined which contracts are construction contracts and which contracts are not. And there is even a list included. The activities, these are treated as capable of forming into a construction contract. So you need to consult the Act to find out whether your contract is a construction contract or not. And then, even if a contract is a construction contract, again, the statute might have said that this contract, any dispute under this contract cannot be adjudicated under the Act of the scheme. So you got to check the list as well. How about the hybrids? For example, if, let's say, a nuclear power plant, there is the contractor who is an electrical contractor. He might be doing things on the plant and at the same time doing things under the same contract on a building. Now, under the construction contract, if you're an electric or mechanical service provider on a residential or a commercial building, your contract is treated as a construction contract. But if you're doing that job on a power plant, that part is not construction contract. Now, if you are in a contract like that, and if your client hasn't separated the applications, or the certificates have not been separated before going to, thankfully you have got case laws from the High Court, before going to the adjudication, please redo an application or change the position from the current month, separating the two, so that you can sever the part which is construction and you can go to adjudication. Finally, and most important point is which procedure to be followed. Of course, it's a statutory adjudication, and Section 108 tells us what the procedure is. And the scheme also provides, Part 1, that what the procedure should be. However, the Act grants you a freedom that you can develop a procedure of your own into the contract, provided that complies with the statutory requirements. So it's vitally important, because it has so many things in it that where do you find your adjudicator? How many days you'll leave for the parties to make their representations? What are the rights of the adjudicator? What are the duties of the adjudicator? So all these will be written into the procedural document. And the choices are, either you have the parties of the contract, or even a nominating body may have their own procedure, which is compliant with the Act. And then that's fine. You can follow that. But if the rule or of procedure developed by the parties or in a contract is not compliant with the Act, slightest difference, that rule will be scrapped and you have to follow the statutory procedure. So it's vitally important to take a preparation on which procedure to follow. If it's a contractual procedure, then you got to consult back the statute and that it is compliant with. If it's not compliant with, the statute will come into operation. And also, it's vitally important that the contract, regardless of if it is this Act or the contractual procedure, which nominating body shall you go to? Which nominating body shall you go to get your adjudicator? It could be that the contract is silent, so you are free to go to any nominating body to get a obviously approved nominating body, we call A and Bs, to get an adjudicator. If the contract limits, it can even name a particular adjudicator, then you have to go to that person. So it's vitally important that you find that out. And finally, now you have decided that you are preparing yourself and you'll go ahead. So make a clear budget. And I will, in the next slide, explain what are the things you need to take into consideration for your budget. Julie? Now, it all depends. How much will it cost would all depend on various things. First of all, what are you claiming for? What are you claiming for? Are you claiming some money or just a declaration? For example, are you claiming that I made an application and I've never received any money? I kept on making my application for the last 3 months. I've never received any money from the employer. The project is going on. My contract has not been terminated. It's quite a simple adjudication. Maybe most of the time, this sort of adjudications are very, very simple and less costly. So you got to find out at the very beginning that what type of claim you're making. You may be making a declaratory claim, meaning, for example, a particular variation is not a variation. A particular change, although is a change, but no money, the contractor is not entitled to any money under it. So two parts in it. Contractor is not entitled, and it's not a variation, or although it's a variation, it's a no cost variation. How about, although there is a change, but the change has not been formalized as a variation or a compensation event by following the appropriate procedure? We are getting into the difficult parts of it. Finally, you sometimes get into the question of, well, I want to claim this money, and what is the basis of that claim? If you have a clause in your contract which says if such things have happened, you are entitled to the money, then it's a simpler claim and you may need less cost. However, if you're trying to say that there is a breach of one of the terms of the contract which resulted into this much damage, so I am claiming the damages. You might be surprised to know that for a long period of time, people thought that breach and damages claim are not suitable for adjudication, although there wasn't any legal bar to it. Lately, we're having such things, but obviously that has different sorts of implications. What about if complex evidential issues are involved, where you need to cross-examine parties heavily? Okay, no, you shouldn't come here. Finally, even if, for example, you think that things are different from what was anticipated by the contract, and that was acknowledged by the employer that these things are different, and you have done something and incurred as a contractor considerable amount of money and has spent a considerable amount of money to do the things right, you may find out that because the risk of such situation or such difference or change the financial risk, lies with the contractor, you do not have a right to make any claim whatsoever. I give you a small example. For example, if your contract involves groundworks, and if you enter into the contract with a particular site condition report, and you go to the site, you start working, you see that the subsurface is completely different. And you go back to the owner and say, look, this is what you have provided me with, this is the report, and this is completely different. I need a different method, I need different type of machineries, much more costly. And the employer says, yeah, I understand that, carry on what you need to do. And you did. And then you made an application, and then the employer's quantity surveyor says, sorry, you took the site risk. Under the contract, the ground condition site risk is yours. So you find it different, that's your problem. I've written into the tendering package that you come and find out what the reality is. We will not take any risk on the condition of the site. The same is applicable even if it's silent. There are case laws which would say that the site risk is on the contractor. So don't get excited. You have to analyze the risk and find out whose risk was it under the contract. Obviously, I have already touched upon if it's a payment dispute under the payment technicalities, it's easier, it's less costly. If it's a valuation dispute under the contract, it's more costly. So while you are preparing for the claim and decided that you have a claim, please, while you are preparing for the cost, keep all of these in mind and ask your professional that, is there an issue of risk involved here before you proceed? Next one. Now you are like in a position to say that, yes, I have a claim and I'll go ahead. I have the money. I have consulted Silver LLP. The senior partner says, yep, you do have a claim. Let's go ahead. What do you have to start doing? Well, or your representative might start doing, or you're advised to do. First up, appoint the professionals. It's just like the employer's architect builds the whole construction team. It's just like that. It's not a single professional's domain, I would say, unless it's something like very straightforward quantum dispute or a very straightforward legal issue dispute. You need multiple types of professionals. I'll give you an example. You have taken possession of a new built house, and on the first week you found that the bathroom is leaking. Fine, everyone can understand that there is a defect, and you go back and they send somebody to fix it, and then in the process of fixing it, that guy said, who provided these doors to you? You asked, why is that important? He said, no, it seems to me that these are not fire rated doors. So you see, you got another type of dispute coming up in your mind under the same contract. And if you want to combine the earlier one and this one, you have to go to different professionals, because the first one is about defect. The second one is about a breach of the contract. And the breach of the contract may be a breach of the contract because it fails to pass the building regulations. The breach of the contract could be a breach of the contract because you gave a particular specification and that has failed. Now, if it's the second type, what sort of professionals you need to go to? You have to find someone who can actually tell you that this doesn't match the specification. So the point I'm trying to make here is that it's not the job of one professional. One will tell you, say, there is a defect. Other will tell you what is the nature of the defect, who could be a building surveyor. Another one will quantify for the cost of rectifying it. And you may need more than one expert to do that. So you need to appoint, or may need to appoint, various professionals to gather the evidence to proceed to the claim. And that is gathering evidence, I said. And gathering the evidence could be factual, and those factual evidence could be oral. For example, the person who really has seen that there were a leak, have you taken a photograph? Because if you haven't asked the contractor to visit the site, and you thought, okay, there is a leak, so I have to do something. So you called somebody came in and fixed the leak. The contractor may say that, look, I was within the defect liability period. If you had called me, I'd have done it at no cost. But because you didn't call me, I'm not going to pay you anything. Alternatively, the contractor also might say that, show me where is the defect. And he said, no, there was leaking and the people came in and this said that happened. Well, I don't know. Can you show me that there was a defect? So factual evidence could be a photograph. Factual evidence could be the materials which have been taken out and changed. Factual evidence could be someone's oral witness statement. But you have to gather the evidence, because just merely stating it on the claim that I have this problem or that problem had occurred will not persuade the adjudicator to give a decision in your favor. As I say, the factual evidence could be oral, could be real, could be documentary, blah, blah. And then, if it cannot be covered by factual evidence, be it oral, real, documentary, you may need to call the opinion evidence of experts, and who's, of course, is a professional. And then you may have to go for testing reports, and then an expert to analyze the reports of the tests you have carried out. So all these has to be completed. If you are sure that you have all the evidence which supports what you're trying to say and your entitlement, then only you draft the referral notice. If you're familiar with adjudication, you might think, hang on a minute, what is this guy talking about? There is a thing called notice of intention to adjudicate a dispute. Do I not have to do it first? Why is he asking me to draft the referral notice? Yes, I acknowledge that there is something called notice of intention to adjudicate a dispute and a service of it. But why I have changed this and asking you to draft the referral notice, you may know it very well if you are a regular practitioner. If you're not, I will discuss in the next slide. But what you need to do as well, when you have the referral notice and the draft referral notice and the draft intention to adjudicate a dispute notice, you got to apply to the A and B, the one you're entitled to apply, and you choose to be, if you have a choice, to appoint an adjudicator. And if you get an adjudicator, you got to accept the nomination and serve the referral notice. All this happens in a short period of time, within actually 7 days. Next slide. So, drafting, appointment, and service. That's what is the stage now. Sometimes I call it from -7 to day 0, from day 1 to day 28, from day 29th to day 5 more days, and then comes the enforcement bit. So it's a journey where we have different time slots. The first slot is today's slot, which is from the time you send the notice, you make an application to the nominating body, you receive the nomination, you accept it, and then serve the notice and the referral. Only in 7 days. The referral is the document which is your final claim document. And it is like the old days, the plaint or statement of claim. It must include, that's the adjudication, all the evidences you want to rely on. I repeat, all the evidences you want to rely on. The provisions of the contract which you alleged is giving you the right to adjudicate. In other words, a copy of the contract if there is a written one. The case laws and the copies of the case laws, or at least the paragraphs of those case laws, case law judgments you want to rely on. Maybe copies of the books, maybe expert evidence, maybe witness statements. You need to have them all under one bundle ready to refer it within maybe 2 to 3 days after an adjudicator is appointed. And the order of sending it is, you first send the notice of intention to adjudicate. I'll come back to it in a minute. And then once you send it out, in most cases, there are exceptional cases where you can apply to nominate an adjudicator first and then send the notice. But in most cases, you send the notice first. That's what the scheme has provided for. And then you send your application to the nominating body for appointment. And generally, the nominating bodies, they have about 5 days to appoint an adjudicator. So they quite often do it on the 3rd or the 4th day. And then from the date of the service of the notice, you have 7 days. So already 4 or 5 days gone before you have accepted the nomination of the adjudicator. So you literally have 2 more days. And it could very well be you start on a Monday morning, and by the time your adjudicator is appointed, it's Thursday. So not only you have to have a referral in your hand, you have to have the whole of the bundle in your hand. And early days, you could just send the referral and say that I'm going to post it tomorrow. That's allowed. There's case law that's allowed. But now, under the COVID situation, you will have no other choice but to send them electronically. And the internet, what it is, it starts playing around when you need them most. So what happens? It crashes, and you try to upload something, it doesn't work. The folders are not going one by one. The first goes before the second goes before the first. All these problems come around. That's the reason I suggest, if you're an experienced adjudication professional, you already know that you have to have everything ready. On the day you are actually sending the notice of intention to adjudicate, you have to have your referral ready. You have to have 90% of the evidences ready, or at least have a clear checklist and start creating folders, files, cross-references to annexes and all these. And as soon as you have the nomination done, you are then ready. You can simply start uploading them. If you want to transfer it via the electronic medium like WeTransfer, Dropbox, and whatnot. That's more or less the week from day 0 to, -7 to day 0, because on the day you successfully serve the referral to the adjudicator and the other side, that's the day when the day when the adjudication time limit starts counting, which is 28 days. And that's obviously one of the greatest consideration why people go to adjudication. Obviously, it can be extended by the claiming party by actually it's a block extension of 2 weeks. Even if that's not needed, your hands are tied. If you want to give it, you can only give it for 2 weeks. And then it's adjudicator's choice whether to use it or not. And after that, from 28 to 42, once that the jump is over, any extension should be by agreement of the parties. What I propose to do, or originally wanted to do, to discuss the referral, drafting a referral, or drafting the notice in detail. I found that the preliminary considerations are so many that possibly I won't be able to cover. Now, I will leave it there, but I'm going to have another one maybe in February about responding to a claim. What I shall do is I shall come back to you with a referral draft template and a notice draft template and a nomination form, and the criticalities of it and the issues you have to keep in your mind and how do you practically tackle them. And I will, in advance with the slides, send it around a day before my presentation in February, where I'll be concentrating on response. And I will develop the presentation in a way so that we can go page by page as a responding party, how to respond to different parts of that claim. I think that will help us to develop the skill and the checklists and the process to how to draft a referral as well. I mean, it's not ideal, of course, but I found that if I go on to explain how to draft the referral or the notice in detail, I'll not be able to cover the preliminary points. I apologize, but that's what it is. I think that's it.
Okay, thank you very much, Mo. And we're looking forward to the next one for more details. Allow me to unstop sharing my screen. Does anyone have any questions for Mo on anything they've heard tonight or anything they'd like to ask? And again, as we mentioned earlier, if you wouldn't like to ask this in an open forum, Mo's details are Mohammed Haque at silverllp.com. Haque is H-A-Q-U-E. The slides that you are able to download from our website have all of Mo's contact details on there. And I'm sure he'd be only too delighted to answer any direct questions. It looks like we don't have any questions this evening, Mo, so you've obviously explained things extremely well, and everyone is now fully on board with the first part of the process.
I think there is something like that.
No, someone said thank you, Mo, for the presentation. They've learned a lot, so it's thanks coming in there.
There was one question I have seen earlier, which was
we had a pre-submitted question.
Yes, if I don't know if that person is still around. I mean, there's no point discussing it unless he is among the participants.
Bear with me one moment, and I'll bring that question up for us. Yeah, someone was asking how dispute resolution becomes formalized and the key factors. I think a lot of that comes in. And we've also got a live question here. When discussing the cost of adjudication, you mentioned that parties may be deterred from pursuing a dispute via adjudication due to non-recoverable cost. What is your opinion of the new streamlined adjudication procedures? And do you think it'll overcome this issue?
Well, that's a bit theoretical question, and it's early days to comment that how that's gonna work.
Mhm.
But clearly, what I can say in brief, that adjudication is a very good process for complex final account valuation disputes of high value, or for claims regarding time extensions. And it could be that, or normally it happens, say last year, I was involved in a series of adjudications in the construction of a stadium. And this was like 4 we had, and eventually the final account was resolved, not very expensive, let's say 10 million was the value, but parties only have spent maybe 70,000-80,000 pounds altogether for the adjudicate, and maybe another 100,000 for the representative cost. Now, if you consider the alternative, that is litigation or arbitration, it would have been 500,000. So many times people think, hang on a minute, I've got like no surety that I'm going to get the cost back, so let me go for it. So, however, the smaller ones maybe are a different thing. So it all depends which type of dispute you're talking about. Does that answer the question? I don't know, but that much I can, that's a brief answer.
Okay. Someone else is asking, can they ask whether damages would form part of the adjudication after a breach of contract or payment claim?
Well, you have asked already like 2 disputes. A payment claim is independent. I mean, the payment technicalities claim, your right to get interim payment and final payment, is something on a technical ground, and obviously we'll be discussing it more in the next type. But if you're talking about a breach and damages, how is this done? The problem is you cannot make an application in which you can include your common law damages at all. You may, if the damages so-called are recoverable, let's say for a loss and expense claim, a breach because of delay, and there is a corresponding loss and expense claim, you may go ahead to try that, and that's very easy, that's very common. But if it is a common law damage, then what you need to do, this is still a breach and a claim arising out under the claim arising under the contract. So what you need to do is send your claim and indicate clearly that you're going to adjudicate under it, and you can just go ahead like a normal adjudication. But the problem is sometimes in final account claims, we also see damage claims. Mix up may create problem for you.
Okay, thank you very much. If there are any more questions, please let us know now. It looks like you've covered those, so thank you, Mo. Thank you to everyone for joining us this evening. Our next seminar is next Wednesday morning, where Connor Ahern revives his QS series. He has a new title in that one, which is Variations. If you'd like to book a place on that, please email me at seminars@silverllp.com. And we hope to see you all again soon, particularly for Mo's next one next month. So thank you very much, everyone. Good night, and safe journey to those of you that are traveling home. Otherwise, we'll see you all again soon. Thank you very much, Mo.
You are welcome, and I thank everybody who attended. Thank you very much.
No problem. Thanks, Mo. Take care.
Bye-bye.